UCAR. Peter Christensen here, coming to you from the CEO's desk. New desk, new year, new topic. Okay, so going to talk about settlement and what it has to do with how you approach a buyer and kind of that conversation. So the Division of Real Estate came out with an article talking a little bit about this topic of the difference between an MLS rule and the law, right? So there's a scenario where a listing agent is approached by a buyer and the buyer's interested in seeing the house unrepresented, but the listing agent tells the buyer, hey, this is there's a new law that requires you get something signed with me before I can show you the house. So let's dive into that really quickly. You can read the division's article because that's the scenario they base it on. Basically, you don't need that's incorrect, right? There's no Utah law that says an unrepresented buyer needs to sign something with a listing agent to see the house. Certainly no legal requirement there. A listing agent is free in their capacity to represent the seller with whom they have a written agreement, an agency agreement in the form of the listing agreement. So they can show a buyer, an unrepresented buyer, the property without any additional paperwork, and that's perfectly fine. Okay, let's switch it up a little, and let's say it's a buyer's agent who's approached by a buyer and to see a home. Well, there you have a couple different issues. Number one, eventually you do need a written agreement per state law to represent that buyer, right? You do need to get an agency agreement signed. Now, the law is a little quiet on when that needs to occur, but for sure before you put in an offer, right? That seems to be where the division has drawn the line. So there is a legal requirement to get something, an agency agreement in writing. Timing is a little different, a little more vague, but certainly before you put in an offer. The other component to that is that there's now an MLS regulation per the settlement that says that the realtor member needs to get something in writing before they tour a property with a buyer. So that conversation, and there's a great debate on what that agreement has to be, but let's say you're going with a buyer-broker agreement. Really, to say to the buyer, hey, the law requires you to sign this agreement with me before we tour that property, I don't think that's entirely accurate. And so I would encourage agents not to use that tact. Really, I think a better way to put it is I'm required to get something in writing with you before we tour the property. That is accurate, right? The MLS regulations require that a buyer's agent get that in writing before they go tour that property. And so it's not a legal requirement at that point. I mean, eventually, yes, you have to legally get an agency agreement signed. But in order to just look at a property, I think the division has said, we're not going to require you to have a full-blown agency agreement to do that at that point, but you do need to get one signed before you put in an offer. So, yes, there is a legal component of you have to get an agency agreement to represent that client in the transaction. But to say, before I can even show you this property as a buyer's agent, the law requires you sign this with me. That's not accurate. I wouldn't say it like that. But to say I am required to get something signed, my industry requires that is accurate, right? Because the settlement does require that. So Be careful you're not using that inaccurately by saying the law. There's a new law. There's not a new law. There are always new laws in Utah, but that's not a new law in Utah to say I have to get something signed before I can tour a property with a buyer. But flip that to a listing agent and showing it to unrepresented buyers. There's no legal requirement. There's no MLS requirement that you get something signed. So don't fall into that trap of, oh, I think I need something signed. No, you don't. If you're representing the seller, you don't need something signed. And certainly no agent should be deceptive about it and say the law requires that you sign something with me, buyer, before we tour a property, before I can show you this property on behalf of the seller. That's inaccurate. I think you're violating all kinds of rules by insinuating that. So don't do that. Understand it's an MLS regulation that requires that you have something in writing before you tour a property. It's a legal requirement that you have an agency agreement before you represent somebody in a transaction. And hopefully that clears that all up. Remember, this is not legal advice. This is legal information only. If you need specific legal advice, please contact your attorney. Thanks for tuning in.